question that companies who are active in the e-commerce sector are currently asking themselves is, what does this investigation mean for us, and how can we avoid landing in hot water with the competition authorities? Now, those are sensible questions to ask. The European Commission is at the moment engaged in collecting vast amounts of data from a huge number of companies who are active in e-commerce across the EU. And we know from past competition inquiries, such as those in the energy and pharmaceutical sectors, that the data that the Commission collects may form the basis for future individual competition infringement actions and attendant possibility of fines being levied on those companies. The cases which followed from the pharma sector inquiry, for example, are a very good example of the way in which the European Commission may seek to flex the law in order to catch conduct that hadn't previously been within its scrutiny. So, looking at the e-commerce sector inquiry, how can we identify where this sector inquiry is going and what the key areas of risk may be? I would suggest that the key, or at least a key, to understanding how the law may develop in this area is to appreciate the centrality of pricing to the Commission's mindset. My colleague Noah Watson-Doig has spoken in another video you'll find on the Bristows Cookie Jar website about the importance to the European Commission of completing the European digital single market. Now, this concept of completing a single market relies on the breaking down of structural and contractual barriers to cross-border trade. But the reason why this is so important comes back to a large degree to price, specifically to price competition around the EU. The existence of national price differences is generally seen by competition authorities as a sign that EU-wide competition isn't functioning properly. If we look at the physical world, for example, for many years the European Commission monitored car prices in an effort to bring increased transparency to the car sales market and to help to reduce the substantial price differences which used to exist in that area. In the digital space, transparency isn't so often an issue, as customers are able to use the internet to compare prices. The delivery of many products and services by digital means also means that there's less scope for price differences resulting from the cost of simply moving physical goods around from one location to another. Although I would add that the sector inquiry is also looking at the question of delivery issues and how those may impede the single market. So price differences in themselves are a fairly direct reflection of the fact that the digital single market isn't yet complete and demonstrate that the market isn't perfectly competitive. But it shouldn't be forgotten that we're not only talking about how companies react to their competitive conditions. In some cases, there may also be a temptation for companies to fight against increased price competition around the EU, perhaps because the higher price markets have traditionally subsidised the lower price markets, or simply due to a desire for higher profits where the market will bear it. And it's in part because of these reasons that I think that pricing issues will be central to the types of cases we can expect to see in future.